There is a proposal. My question is, there is a proposal that Mr. Honorable Kaluma and Mr. Nyamori have spoken about on how to enforce or how part of the law of Kenya under this constitution. So have we looked at the ICCPR? Have we looked at the General Comment number 37 of the United Nations that is trying to explain ICCPR Article 21, which is similar to Article 37? Have we looked at those provisions? Have we read the General Comment on how to police assemblies, to the extent that we've realized that they are so insufficient, and therefore we need to actually come up with our own domesticated provision on law? So what is this lacuna that we are trying to cure, that General Comment number 37 of the United Nations and Article 21 of the ICCPR has failed to cure? Because from what I see, there is the element of mischief in trying to come up with such laws, because they would be doing more harm than good. Thank you, Effie, back to you.
Thank you very much, Wakili Poli Okello. I know my international human rights law teachers are yearning to respond to you, and I know Duncan will respond to what you have brought in under Article General Comment number 37, tied with Article 21 of ICCPR. But before he does that, I want to give the space to PLO to weigh in. Mwalimu Ivan Sogada is also in. Mwalimu, I don't know, before you leave, whether you can take Poli's question and just give it a bit more meat before Mr. Duncan also responds. PLO, please.
Hi, good evening. If you can hear me?
Yes, we can.
Thank you, and greetings to all colleagues on board. I've been following through the discussion. It's been cogent. Sometimes it's been getting a bit heated up, but nonetheless, variance in terms of communication and understanding should not be construed to mean that either of our submissions, should be watered down. First things first. When we talk about Article 1 of the Constitution, and of course, vis-a-vis Article 37, well, I've been listening in, especially from the contributions by Honorable Kaluma and Mr. Nyamori. Before we even talk about, limitation of, the right to peaceful assembly, or the peaceably, the semantics between those two words, why wouldn't we talk about what precedes those limitations? Why don't we talk about, the ingredients that have made, citizens to go to the streets first to have those grievances addressed? So I'm talking about accountability. And for me, the 13th Parliament has actually abdicated its role in terms of not just representation, but equally in terms of legislation and oversight, because those three faceted approach of bicameral parliament are so key in driving this conversation. Honorable Kaluma, you would agree with me that before the report of the consideration of the Finance Bill 2024 was tabled before the National Assembly, the chairperson of the Departmental Committee on Finance and National Planning went to the House on the Hill and made the quote-unquote concessions through a press statement before the report was actually tabled before Parliament. What does that tell you? That tells you because the executive does not make laws, but the fact that parliamentarians from the ruling party went to the House on the Hill and the chairperson of the Finance and National Planning Committee read a statement to the entire country on the concessions of that particular bill, even before the report of consideration of that bill was tabled before Parliament, tells you there's quite a disconnect between where exactly does the independence of Parliament, begin. And I think that is why on 25th of June, that is when the legitimacy of Parliament was actually watered down. I would say the delegated power of the people to the representatives. I don't know if they're still the representatives, but it is quite disheartening that the representation is not actually seen. So Parliament of today, the 13th Parliament, is more or less like an extension of the executive, because it's hard to decipher between Parliament and executive, because when you make some of these grievances, parliamentarians do not actually factor them in. So how do we draw a balance rather between representation and of course oversight of, on the executive exercise? And the role of lawyers in addressing this is anchored under Section 4 of Cap 18 of the laws of Kenya. And it states clearly that lawyers or advocates need to, assist the government even through legislation. And we've seen a couple of, legislation that are being either tabled before, Parliament. Some of them are too punitive to the common man. And the Finance Bill 2024 perhaps was, just the ticking time bomb. So it has been like a snowball that grows before it completely crashes on the citizens. So my worry would be, how does the 13th Parliament actually redeem itself? Because whatever the Parliament does necessitates these particular protests. And of course, in collaboration with the executive, and accountability, transparency, and our public debt of today, which I think stands at around 11.35 trillion as at March of this year, and Parliament is largely to be blamed on our fiscal indiscipline to begin with. And this has, of course, has the ripple effect on the cost of living on the citizens. And that is why you would see them on the street, because to put food on the table is actually so hard. And when Parliament breached the debt ceiling by amending the Public Finance Act, I think that was the beginning of our downfall. And I can't remember any other statute that perhaps has gone through more amendments than the Public Finance Management Act. And it's so disheartening because our debt stock is actually unsustainable. So we would keep on, borrowing each and every time. So I think, Honorable Kaluma, it will be in our delight if parliamentary, and especially the 13th Parliament, well, I still have that modicum of hope in them. And if you can redeem yourselves in the next 2 years, then we can have a conversation. But as of now, what we see for the 13th Parliament is you don't listen to the people. You may have our intentions at heart, but the instructions are always different. So as I wrap up my submission, I would just like to close by what Socrates once said in an argument against Thomas Hobbes' social contract theory. Now, when the social contract becomes frustrated, then it means there's no argument between the sovereign, who are the people, and the crown. When they say the crown can do no wrong, literally, that is what is replicated in our own system of today. So when Socrates said that he would rather stay in prison and accept the death penalty rather than escape and go into exile in another Greek city, what he meant is, even if he were to go to, say, Kiambu of Durban, or even Garissa or wherever, that burden that weighs on every Kenyan will still be on his shoulders. So it will be my humble submission that we rewrite our narrative, that you as an advocate, Honorable Kaluma, and of course you have so many of your colleagues in the 13th Parliament, how do you restore the trust that has been eroded? And how do you bridge the gap, that has been widening each and every time between the Parliament and the citizens, who are the ultimate sovereign? With that, I do humbly submit. Thank you.
Thank you. Thank you very much, PLO, the resident speaker with big English. But Mr. Duncan, I know you want to weigh in on what PLO and Polycarp have spoken to, and because much has been targeted towards the National Assembly, we'll have Honorable Peter Kaluma come back in after you finish. Daktari.
Okay, I'll be very brief. One, Nyamodi brought something, Advocate Nyamodi, that right to picket peaceably. Now, isn't it oxymoron that all we hear is the ones who are in the street are angry? I don't know to what extent can somebody be peaceable or peaceful if they are angry. In other words, the Constitution does not give qualification to being in the street and to picket. Whether you are angry, whether you are mad, like a mad dog, whether you have no good reason at all, it's a right you can enjoy. You can come. There is no criteria or a super legislature who check on why you are in street and see whether you are there for legitimate reason or not. So the emphasis on the angry Kenyans are in the street is not necessary in law, or it's not a prerequisite to exercise that right. But it raises to me an issue whether that person who is angry, and so angry as we saw others even saying, I'm ready to die, whether that person can be peaceful. Perhaps one of the qualifications is go to the street before you are angry, because that way you can exercise that right in a way that is peaceful, because it is an oxymoron to be peaceful and angry at the same time. I'm just coming back at this narrative of people are angry. That's not a requirement to being in the street or to picket. And if that is where, if it's a matter of where to exercise anger, let us find another source in the Constitution, but not the right to picket is not meant for people who are angry or because you are angry. It is because you are peaceful and you have a reason, whether you are angry or not. Number two, when you look at the local context of even the limitation we get in ICCPR and whatever, you know very well that the Supreme Court have defined this element we have of our sources of law, where the international law comes in, and where the drafters made a mistake of even talking of the law of nation, or whether it has become customary law. I think that's what they were talking about, whether it's international customary law. The entire ICCPR has not risen to international customary law. And you know the Kenya Court of Appeal, in the case of Mitubel, were very clear that our sovereignty extend to our law. And we're telling Judge, especially Judge Mumbi, that you are very bright legal mind. This thing of adopting and being adopted by international standard, anything UN, anything, whatever becomes source of law is not proper. And just make our law endogenous and indigenous law. That's the Supreme Court goal. So I don't think that in our local context, the right to picket under ICCPR is even as advanced as we are one of the few nations where the right to picket is anchored in the Constitution. So the ICCPR is way below where Kenya provision is, and therefore the solution must be local. But I think in my conclusion, as I respond, we are mixing both internal self-determination and external self-determination. For me, the right sovereignty belongs to the people. It's really describing right to self-determination. You know that internal self-determination includes voting, includes this constitution coming so advanced to say how to even recall a member of parliament, includes public participation. Those are internal. External means quitting the state and coming with a different country, like the one Ndi drew for the region that were picketing that look like a loaf of bread, saying, let's move from Kenya. That is external. That is extreme. And when it is administered under international law, under the Congo case and whatever, it's only extreme. So when we talk of internal, and internal is how to talk to your leaders, including picketing, then there is no so much place for collective responsibility of talking of this parliament that. Because the Constitution has said people can recall their member of parliament. So this idea where we only talk of And you know that that's where people are represented, but they are representing each individual constituency. Now, the Constitution has even gone as far as giving you how to recall that person. Nobody wants to do that. But we quickly come, as we sing in our SDA church, prone to wonder, Lord, I feel it, of blanket condemnation. This parliament is up to no good. Now, let me ask you, let me give you the best of your argument, the lawyer from PLO farm, that let's give the argument that this is the worst bunch of parliamentarians. Voted by others representing all these other people, constituencies that voted for them, is a bunch of people in the street, better representative of what Kenyans think than that parliament. So that we are saying, as the PLO lawyer is telling us, that the parliament has failed. Now, these people who have come, whether we come from our neighborhood in Kasarani or wherever, 100 of us, and we get to the street and say, now because the people like Kaluma have failed, who are voted by the people, who represent the people, and we think they're up to no good. Now, this group of mine from today are now going to come with ideas that are universally acceptable. Who then sit and check whether my idea is more acceptable? Is it in the X space? Is it in the Twitter because I put it in Twitter and I have 100 followers? Is what I'm doing better at representing and carrying the people's voices than the house of the people? But this is the culture of hypocrisy of Kenyans, that we bash institutions. When we want them, we go for them. When we don't want them, we bash judiciary, we bash parliament, we bash the government. You know, in other places, everyone working for government, they start by saying, thank you for your service to us. We are always bashing our institution and reducing it to the individual in there, not knowing that we're actually weakening our mechanism of check and balance, so that we glorify the individual. And as I started, and as they say, when one finger is pointing, four fingers is pointing at the pointer. The four fingers is, are Kenyans living according to constitutionalism? Are Kenyans living according to rule of law? And the answer is clear, no. Look at the chaos. Even when people come to the street to picket, but quickly it turns to these parliamentarians. There is individual responsibility. Let us not blanket bash the parliamentarians. We have even a right to recall, and let us look at each one, and still at its worst, it is better than a bunch of people in the street telling us, now ignore parliament, we are representing you. Thank you very much.
Thank you, Dr. I don't see the MP for Homa Bay. I don't know, I think he could have dropped at some point. Please, I see him logged in, but he doesn't have the mic. Mhesh, if you can request the mic, and we'll enable you. And Nyamori, would you please respond to that as we enable Mhesh?
Yeah. Allow me to, can you hear me?
Yes, we can.
Yeah, allow me to respond to the question or the input that raised the issue of the general comment number 37. In my view, I would start this response by saying that Article 37 is not absolute, and our Constitution provides for that, and that it is subject to Article 34, which allows lawful limitations on the rights of, in a democratic society, for public order, security, and rights of others. And now, when we look at general comment number 37, it does not grant unlimited freedom. It explicitly acknowledges that states may impose restrictions, provided they are, one, prescribed by law, pursue a legitimate aim, e.g. public safety, and are necessary and proportionate. And I think this is what Honorable Kaluma, and this is what Dr. Duncan Ojwang, and this is what I am raising, that we can pursue regulation of the exercise of Article 37 by prescribing it in law, by ensuring that we pursue only legitimate aim. For instance, what we saw on Wednesday calls for actions to ensure public safety. I don't know whether it's true. I just read that the storming of a police station resulted in, death of three suspects in a cell. So the other day we were making noise about Ojuang, who sadly died in a police cell, and we are hoping that the people who are responsible will finally be punished according to law. But then here that hooligans have, for political or other reasons, stormed the police station, set fire on vehicles and on the building, and tried to storm and access the armory. And it has resulted in the death of 3 people who were supposed to be safe in a police cell. And then there is an argument that we cannot prescribe a way of regulating conduct of such hooligans when people are exercising the right to Article 1. So in my view, that right can be restricted. And then the Public Order Act is part of the legal framework. So Public Order Act makes provisions for prior notice, for routes to be approved, and for assigning liabilities. And if Public Order Act, therefore, is part of our legal framework, then it satisfies the requirement of General Comment number 37. And these are not violations of any rights in any case, but will be tools to balance freedom with order, which would be necessary for all of us to, exercise our rights. Now, the state's responsibility versus individual rights is something that I believe that we need to look at. And the state's responsibility, the state has a duty to protect all persons, not just protesters, from violence, disruptions, and lawlessness. I listened to the MP for Kikuyu, who is the majority leader, saying that his 105 years old father and 85 years old mother was subjected to harassment, and a crowd went there to, in his words, to murder them simply because he holds a political view. Whatever view that the MP might be holding cannot allow anybody to use the excuse of Article 1 and Article 37 to go and threaten the lives of a 105-year-old.
Wakili Nyamori, I think we lost. I might have lost you at the tail end, but allow me to bring in Mahesh.
Sorry,
Honorable Peter Kalu.
Can I just?
Oh, yeah, okay.
1 minute.
Yes, yes.
Yes, I think you may have lost me when I was referring to the DPP versus Ziegler, which is a 2021 case in the UK. It says that the right to protest is protected, but may be limited where it interferes with the rights of others for public safety. And then as I finish, it is also important that we look at the UN guidelines, the US guidance, that is GC 37, which at paragraph 15 provides that organizers are expected to comply with lawful requirements. And then paragraph 84, which provides that states may use proportionate force to prevent violent assemblies or and restore order. And so my view is that the bottom line is that sovereignty is not equal to license for lawlessness, and that the right to protest is not equal to the right to riot, and that Kenya must uphold the rule of law and not mob justice. And to do that, it is also important to appreciate that when the CS for internal security, maybe the way what he said came out may have not come out well, but what the CS was speaking about is in law. It is in law because the police is allowed in law, and we should not teach our children the police is not allowed. Police is allowed to use lethal force in certain elements where the life of the policemen and lives of several policemen were under attack in the last few days. And then when protecting property, when protecting protected areas, including police stations, and so on and so forth. So my view is that we must teach our population their rights, but we must also teach them the obligations that come with the exercise of that those rights. Otherwise, we will be getting into anarchy. Thank you.
Thank you, Wakili Nyamori. Mahesh.
Yeah, I thank you. Sheila. I've been very enriched by the sharing of perspectives on the forum. As I said, the time has come for us to make a law to better secure the enjoyment of the rights under Article 37 of the Constitution beyond the Public Order Act and based on our experiences. And so let me just confirm that I'm keenly listening. I'm happy this conversation is being recorded. I'll be making contact with a number of us who have spoken here, including Brother Joshua Nyamori. Has some very good references, which I know will enrich, that law, which, as I've said, must be enacted this time. Duncan Ojuang, Professor Gada, and of course, Stephen Bugu and all other participants. I will listen through to the end, even when I later break. Number two is just to emphasize that there have been several attempts in the past to have a law, guiding the exercise of rights under Article 37 enacted by Parliament. I think the last endeavor was by Honorable Rocco, now the CS in charge of labor. I personally opposed, those endeavors because they were not being brought as bills seeking to limit the rights as required by Article 24, but they were approaching the matter, differently. So let me just emphasize to fellow learned friends that every time I've said I want to pursue a legislative agenda, I've never gone back. We now have the Companies Act, we have the Insolvency Act, we have the Marriage Act, we have the Matrimonial Properties Act. and several other enactments because of the farmer position some of us, including myself, took then in the Justice and Legal Affairs Committee. So this one must be enacted. I dispatched a note to the Speaker yesterday, setting the parameters which I see out of this deliberation we are going to expand. And so let me encourage our colleagues within the Noble Law Society to send views either to me or through the council as we put together the text of the bill, and even later when we go to public participation when the bill is published, because that ideally is one of the things the respective statute. So let us have that, public duty being discharged in terms of, setting the parameters. And of course, I'll be making those references. Number 3 is just to emphasize that there is nothing Parliament does which can be undertaken without public participation. The courts have already defined and always defined must be meaningful. No single thing can be done by Parliament that does not go through public participation. This is a requirement as a value and principle of governance under Article 10 of the Constitution, and it is also a requirement under Article 108 and 118 in terms of parliamentary procedure. The problem we've had as an institution, and I'm saying this out of experience, is that, sometimes the people in the know do not come forth with information to aid Parliament in making laws or making decisions for posterity in the manner contemplated by the Constitution. There are cases, and I know the Council of the Law Society of Kenya will confirm, that we've even waited for views of individual lawyers and you don't get them. To an extent that in some instances we've had to, write to the Law Society, for the views of the society to be brought aboard. And in a number of those circumstances, we've been enriched by those views. The request I'm making is that maybe we need a committee or a subcommittee of the Law Society that can be more intensely and intricately interacting with Parliament on matters legislation, because all bills being enacted by Parliament or motions are normally notified at first reading, and they are all on the website. So let us, in the discharge of our duty under our foundational act, be giving these views. And I can tell you, I've been in Parliament, in the 11th Parliament, 12th Parliament, 13th Parliament. I can say without any fear of contradiction that comparatively the current Parliament is more engaged than those previous parliaments. Maybe Parliament could be failing on their public relations and in the manner in which they present the undertakings to the public. But I can tell you, this is the Parliament which sits, you remember, like yesterday, we were sitting up to midnight. Every Wednesday, today, unlike before, we sit up to 9 p.m. And you get Parliament engaged, very actively. Look at the legislations and their impacts in terms of number and in terms of their impact to the society, the matters they're dealing with. The number of bills that the current Parliament has been enacting are way beyond double the bills enacted by those, parliaments in each session, in each particular instance. So I want to assuage those of us who believe that this Parliament is any weaker or any lesser or not participatory to, get out of that thinking. Allow me to clarify just one or two issues. One around police reforms. We have units of the police, there is a unit called Critical Infrastructure Police Unit. Those critical infrastructure police unit officers guard our critical installations and offices, including the judiciary, the State House, Parliament, and of course, a number of government offices, taking into account the sensitivity of matters they deal with. Let me not, shy from telling you that anybody who breaches, such guarded institutions in the manner we saw the judiciary, the Supreme Court nearly being put under fire, will give the police the reason to apply lethal force. I don't think we can expect police officers, if we were to speak for the Supreme Court, for instance, to allow people having entered the court and they are violent to wait for them to kill our Chief Justice there. Those are people I can say on this forum without any fear of contradiction that they will find themselves in the arm's way. And I don't think there would be much you would do in the police to, when we talk about the police, let us also be mindful children, our spouses, our fathers, our mothers, people we all know that they are citizens of this country. And contrary to the thinking that because one or two police officers, engage in misconduct, all police officers should be condemned. I'm one person who will, in a detailed manner, having served in the Security Committee for now 13 years, continuously tell you the reforms in the police are apace. And if we have cases of misbehavior or mistake by the police, it must be individual. The larger majority of our officers are very good. Let me say that even on the Albert Ojwang case, if it were not for the intervention of one or two good police officers, we would not be where we are now. So let us not have wholesome condemnation of the entire institution of the security organ called the police. Let us instead hold those ones who go away from the Constitution, the law, and the National Police Service standing orders accountable, and we sanction them expeditiously and adequately. But that is where we are. Number two, we must ask ourselves in the context of enjoyment of the rights under Article 37, that what are the parameters proper? I'm enriched by the definition of peaceably, and I will not want to take the members through it, but I would urge all of us, wherever we are, just Google peaceably, and you'll see how rich and the details. So that the category of people Dr. Ojwang is talking about, when you already say you are angry, really, you are a person who, ab initio, should not be allowed the enjoyment of that right, because peaceably does not contemplate that, you are angry even before you invoke Article 37. When you are saying you are on the streets to seek compensation, I'm giving an example for people who are killed, which is a just cause. Should we also not question where, therefore, you should claim, that just end? When you, instead of petitioning the courts or parliament for compensation, you say you are going to occupy State House. When you know the president under Article 31 is the commander-in-chief of Kenya Defense Forces, which are the Army, the Navy, and the Air Force, not the police. And when you know the National Police Service is now an independent service under the sole and independent command of the Inspector General of Article 245, are you still within the remit of the course you are pursuing, or you are now on extraneous, at times even a political cause. When you start, claiming compensation, and now you are singing things like one time, I mean, where do they interact? And when you go blaming people who are not the institutions that are, charged with whatever maladministration you are challenging by way of public administration, like you go saying, Ruto must go. How does Ruto compensate somebody who has been killed? So these are all issues we should, look at keenly in terms of, in my view, as lawyers. To end, let me just say that we must always remember that in this context, we are discussing Article 1. But Article 1 says sovereign power belongs to the people. So who are the people? Is there a section of the population which can define the people? Unless it is a section like a constituent assembly in constitution making, like the one we had at Bomas. Can a section, whether generation or people from a region, define their grievance and decide by themselves without a referendum in which the entire population signifies their position that they are the people, and so if their grievance is not treated in some way, they can, seek recourse to Article 1 and Article 37 and do as they will. I would personally disagree with that position, because if we were to accept it, then you need even to look at what we are calling Gen Z today has morphed over time from 2024. The demonstrations we had, the other day, we didn't see the march demonstrations in Homa Bay, which I represent. We didn't see any demonstrations in Migori, in Kisumu, in Turkana, in Samburu, the entire northeastern Kenya, and of course, quite a number of places. Are we saying that those people do not have Gen Zs, or what are we talking about when we want to say that a section now being emphasized by a category of Kenyans calling it Gen Z can do as they will? I think we need to, define things properly. And my view is that where either we don't, as a people, constitute an assembly getting and deriving authority from all of us in the manner, for instance, we constituted Bomas into a constituent assembly for purposes of constitution making. Any, sections of us claiming to be the people could just plunge us into anarchy, because that way you don't have homogeneity, you have heterogeneity, and you have a situation where, the so-called people are not added them in terms of what they are pursuing. So we must, look at those things in that concerted way. But also to say, you remember at the end of the Gen Z demonstrations, which were about the Finance Bill 2024, which was withdrawn. The withdrawal was sanctioned by Parliament. Immediately after that withdrawal, it was now, we are going to State House, we are changing, power. I wanted to say that these rights we have in the Constitution are, to be enjoyed by all, including Kaluma, who is an advocate of the High Court, but has been privileged by, the people to represent them also in Parliament. And let us agree that the enjoyment of all these rights must be looked at as a whole. Our political rights. Currently, I'm in the broad-based government, and I'm not ashamed of it, because I made a deliberate decision to be there. So it is no reason for somebody to come to the platform to define for me in which political formation I should, because I also have that as an Article, 38 right, just following that 37, my political rights to choose the political formation and not to define for anybody else their political, formation. So let us, move together. Let us always, be collegiate. But as the society of lawyers, I want to say that Kenya is in a good trajectory. We just need to be more vigilant. We just need to intervene more. We just need to be very alert. And where we are dealing with Article 37 rights, let us secure that the end is clear. I'm a guy who, from the time I joined university, Professor Kivuta Kibwana, Dr. Willie Mutunga, Davinda Lamba, Professor Kecho Witi, then, created, what we called forces, NCC, National Convention, Executive Council, Clarion, and we started for constitutional clamor. And at that time, we were saying, no reforms, no elections, no constitutional reforms, no elections. You see, even from the beginning, even from the chant, the end is very clear that if there is a constitution, we would not be agitating. When we were demonstrating, when we were in, Azimio up to 2023, we were saying the cost of living must be dealt with, and we were setting out with clarity the end of those demonstrations. When Gen Zs came together, they were saying the finance bill is imposing extra burden on the people of Kenya, and really it needs to be rejected. And so the end is clear. How do we proceed to enjoy and exercise Article 37 rights in an environment where even the end is not defined? And so let us introspect and ask, if you see, for instance, that unfortunate lady whose son died, Josephine Onyango, is moving to the street with the former Chief Justice saying they need compensation. They even says it was promised by the president. Of course, the president cannot compensate because the budgeting authorities in parliament, and determination of compensation is before the other arm of government. Now, they ran on the streets. They had even to suffer the consequence of those disruptions by whether hooligans or the people who called them, you see tear gas on them. At the end of the day, she went back. Now, absent petitioning, which is another mode in Article 37, where does that place her? And what is the end of it when you just say, people, let us go to the streets, Sirini number, one term, Ruto must go, then the end is not clear. And when the end is not clear, we must therefore have a law which says, when you give notice, you will be saying you are going to demonstrate, you are going to protest for such rights, and this is your aim. And so that you can also be guided. If you want this, Article 37 also provides for petition. Why don't you petition this authority on this defined manner, and we move together? Otherwise, let me thank all. I yield back, believing that such platform should always be there so that we share more across, the legal spectrum, fairly as learned friends, privileged to serve the nation in our different ways. I thank you very much, and I yield back.
Thank you, Honorable Kaluma. I hear you in two things. One is that we need synergy between LSK and the National Assembly on even the laws that come up. Several times, advocates will agree that we have seen emails calling for our views in terms of the laws the bills that are before Parliament. But perhaps we should now explore a working committee that advises on the legality of these bills, even before they go on to be debated, and before they now come back for us to go and apply to court to have them struck out for going against something. We can build on that synergy, and it's a conversation as a law society we will be having going forward. The second thing I picked from you, Mhesh, is that we are at a crossroads that demands dialogue on the way forward. Because if we are to go on with our hard stances, for lack of a better word, from the Gen Z side, the hard stance that the government has to yield. From the government side, the hard stance. And if you look at what CS Kipchumba Murkomen was saying just yesterday, the kind of hard stances that each side is taking. And I think all of us have to agree that at some point, we have to yield to agree to what is workable, even as we approach a peaceable position from both sides. But allow me to bring in Freddie. Freddie, you have the mic. Please weigh in, then you'll be followed by Polycarp, who's requested the mic again.
Yeah, Sheila, before you yield, what you say reminds me of a thing, if you'd permit.
Yes, Mahesh.
Yes, I'm grateful to the speakers already nominated for the indulgence. You remember when we ended in 2024 the GMC protests, and you remember somebody like myself, I speak with a free conscience because I voted no, and the records are there. We at the end sat and we were asking, now that the finance bill has been withdrawn, what do we do going forward? Has it cured all the grievances the Kenyans went to the streets for? And remember, this street protest started in 2023. And we concluded in a meeting that we sat through for, a whole day, and a meeting which was on television, that really, if we just end here, we would lose much more we would have gained. And so you remember, we sat and called for a National People's Convention. Because we were saying, now that this thing has moved from the finance bill to Kufa driver, Kufa Makanga. If the driver dies and the Makanga dies, the driver symbolized the president has to be removed. The Makanga was the deputy to be removed. Then as a lawyer, what is the posture? And I remember I took a very firm position, and I said, where we don't have the president and the deputy president, we will go straight away into the hands of the Speaker of National Assembly, who can only sit for 90 days. After those 90 days, of course, we go into an election. And then we were faced with the reality that, okay, now if elections is the only thing, then we don't have the Electoral Commission in place. What happens after? After that, it is only the military that can take over. And what they would start with is the overthrow of this constitution with this rich Bill of Rights we had. And so you remember we resolved and we said, let us have a people's convention so that this thing that is being said that leaders are not listening, let us give people a big forum. And we even said the young people would take the first 50%, but we nominate cross-section members of the society, including Law Society of Kenya, so that we can identify, we can go to the underlying cause of this thing beyond the finance bill. And you remember the response then was that we are now traitors, we cannot do anything. I'm happy that now people, even the young people, when you watch them on television, they are saying we need to be listened to. Let us agree in principle that matters which we can resolve on the table, we take opportunities to do so. And let us, also agree that in as much as we can, we may not communicate to all Kenyans and communicate adequately and communicate in the manner that is desirable to sections of the society. Really, sometimes our talking together to agree could be more beneficial in terms of our progress, even in the legal realm, than taking antagonistic and rigid positions on things that we can resolve together as a people. So we are back, and I'm happy there is opportunity to talk. And in that opportunity, as I've told you, I learn in every space, and I eternally thank you for involving me on this one. And I think if we can create that forum, then you would realize that most of these things people are complaining about is because it has not been presented to them, so that together as Kenyans we look at how we are. So let us avail ourselves of those opportunities. And I think one thing you could also resolve is that something that involves cross-sections of Kenyans to diagnose the state of the nation in a very objective, apolitical way is necessary, so that we separate politics from realities, and so that we secure the space of good governance, even when we engage in political ventures. I thank you very much.
Thank you very much, Hesh. Yes, Freddie.
Yes, good evening. Can I be heard?
Yes. Try to be a little louder. We can hear you, but your volume is so low.
Sorry, I'll try. Now, first, thank you for the chance. Now, to talk about a little bit about Article 1, about sovereignty of the people. In my view, sovereignty of the people is a concept that has three manifestations. That is the power to frame government, the power to choose rulers, and to be involved in governance. Now we ask ourselves, who are these people to frame government, choose rulers, and governance? These are the people. So that if you look at our constitution, unlike the repealed constitution, at Article 1 we have the word sovereignty of the people, trying to say that even before this constitution, we existed. You look at the preamble at paragraph 7, that talks about the people acknowledge their sovereignty. So it says that even before that Article 1, they already exist. Now, if we talk about the power to frame governance, we say that the first one is that when government is being framed, we are designed to be part and parcel. We have to say that we belong, we participate. Power to choose leaders means that then we have the right to vote the leaders we want. So that if today I choose Honorable Pondo Kaluma, and maybe I feel it's not doing well, then the problem is not with him. The problem is with me, who have chosen him. Perhaps I might be worse than him. Now, when you talk about to be involved, it means, as Honorable Pondo Kaluma says, that there is involvement of the people. Then we know that when decisions are being made, the people are involved. Now, when we talk about this idea of the people, how do we interpret this constitution so that we understand even our rights? Now, there's a theory of interpreting the constitution, and I believe Mwalimu Dr. Gada is listening. He may correct me if I'm wrong, but there's a theory of interpreting the constitution that believes that the writer of the constitution must be seen as someone who is not sophisticated. That this particular author of this constitution is an average person. An average person. Another person, just think of most important things. In fact, if you were to ask them of anything, the first thing they will start with is about food. Then the other things follow. So much so that when we talk about sovereignty of the people, it therefore means that it's the principle that is given the most weight in the constitutional provision. Now, looking at Article 37, because we are talking about Article 1, vis-a-vis the demonstrations that we had. Now, Mr. Nyamuri talked about Article 37, and I agree with him when he said that it's not absolute. Maybe what I can add is that that right under Article 37 to picket and demonstrate and even assembly can be protected. The state is not giving it to you, but it can be protected to ensure that it does not infringe or inflict, it does not limit or does not infringe on any other individual's right. As you demonstrate, there are other people who are not demonstrating. It doesn't mean that if I'm doing my business, you come and vandalize my business because I'm doing business. I hear some people say that we are fighting for you. Some people may not even understand why. Like somebody was asking me on 25th, why are these people demonstrating? And of course, I was quick to tell them that they understand the reason why they are demonstrating and it's their right. Now, as I said that this is not a sophisticated person. These people think about food to start with. It doesn't therefore mean that if I have a grievance against a particular person or a particular office, then all of us in this space are must join me. No. Now, this Article 37 therefore is subject to limitation in the sense that its enjoyment may be curtailed in certain circumstances. Now, just to conclude with, I remember what we were taught about the Grundnorm. Changing the constitution is not a remedy. Changing leaders is not the remedy. because the Grundnorm will always remain, because we know the Grundnorm is the presupposition of the legal order. So that even if today we were to change the laws or we were to change leaders, the Grundnorm will always remain. Now, sometimes it's our attitude towards these laws, so that we do not even have to make so many legislation. In fact, we have forest of legislations. But the question is, how do we respect the rule of law? So that at the end of the day, when we are demonstrating, we are not seen to be curtailing other people's rights. We also let others enjoy their rights. And I think I'll stop there. I do not have much to say. Thank you for the time. And I also thank the previous speakers.
You're on mute.
Sorry?
You're back to mute again.
Where did you lose me, please? Because I've been talking all through. Sorry.
Please unmute.
Yes, Sheila?
Effie, can you hear me? Can you hear me, Sheila? Hello? Am I audible? Hello, can you hear me?
We can hear you.
Okay. As a rejoinder and maybe in conclusion and at some point to agree with the previous speakers concerning various questions that I asked and my friends asked that at some point converged, I'd like to agree to the extent that peaceful assemblies should not be pursued, or as the law is, should not be pursued on controversial goals that would end up causing disruptions or in any way turning violent in any manner. And that is why at the moment there is so much going around whenever we hear there is a demonstration that is going to take place on a certain day, because over time these demonstrations have morphed into something that is not attaining the particular goal that was intended in the first place. So we are not saying that, I am not saying that the government has got some responsibilities that makes it 100% on their side, but I believe that there is another responsibility or on the obligation on the part of those who are participating in these demonstrations. For instance, the controversial goal in this case that we describe as morphed is where we have political objectives being included in the initially well-intended demonstrations. And the moment that we have a demonstration with the clear objective of what it wants to achieve, the moment that has been achieved, then we need to go back and analyze whether the things that have been presented to the table or the things that have been achieved so far are addressing the reasons why we went to the street in the first place. So we've just had the political elements being part of it, and that is why we have seen such kind of reactions at the end of the day. It's not that, I'm not saying that the fact that there are political elements that have infiltrated the well-intended demonstrations justifies the resolve or the actions of the police. No, I'm only saying that peaceful assemblies should not have controversial goals or cause disruptions, because we've had that discussion around peaceable, peaceful. So I agree to that extent. So there is also need there is need, and so far I think we haven't really addressed this issue of spontaneous assembly, which are typically are a direct response of contemporary events. For example, the issue of Albert Ojwang raised a spontaneous assembly. We are still ill-equipped in policing or managing assemblies whenever we have spontaneous, peaceful assemblies. And that's why even with the suggestion of Honorable Peter Kaluma that we need to have a system which is in place through the Public Order Act, though it is not mandatory, it does not in any way invalidate any assembly, because the notice in itself is to aid the enjoyment of the right. However, back to the spontaneous assemblies have been ill managed, or the police have so far failed to manage spontaneous assemblies. And that's where it takes us back to the issue of notice. We're in an age whereby the issue of notice might not really suffice. The Public Order Act, looking at the historical events behind the enactment of the Public Order Act, you'd understand why the current state of affairs does not in one or the other favor such kind of regulations beforehand. And therefore, we need to find a way to manage these assemblies that just come about and do not require any form of notice. And just like I said, it doesn't invalidate an assembly if there is no notice issued. And to conclude, such fora, for example, the one that has been organized by the Nairobi branch, is an important step in addressing an important aspect that has so far been overlooked. And this aspect of training of those participating in these assemblies, there is that need, there is the responsibility to train those participating in these assemblies on what is required of them and what is not required of them. The manner and the mode of enjoyment of their rights is very necessary, because, like I said when I started off, these rights are enjoyed by individuals. They are not a collective right. They're just enjoyed collectively, but the responsibility falls on an individual. That's why it becomes an excuse for the state agents to claim that there were criminal elements, because these criminal elements are not going to be liable as a group. They ought to be liable as individuals. It means even when we are enjoying the rights to peaceful assembly, these are rights that are enjoyed by individuals but collectively exercised. So what am I saying? I'm saying that there is need to train. There is need to train the people enjoying or participating in these peaceful assemblies. And we also need to explain to them and to demonstrate the meaning of peaceful, peaceable, non-violent, and violent means of exercising their rights. So it is a responsibility that goes back to the state, that goes back to the Law Society of Kenya, that goes back to those people who know better, to ensure that we have such kind of fora where we explain to the people what entails enjoying their right to peaceful assemblies. Thank you so much, Effie, and back to you.
Thank you very much. I don't know whether in winding up, Wakili Nyamori, you'd want to go first, and then the other speaker present is Mheshimiwa Kaluma. I don't know whether you had summed it up, or just have a closing remark as we finish.
Wakili, I want to just say that this has been quite enriching. I was just looking at General Comment number 37 of the ICCPR, Article 21, and I note the fact that it says an assembly is a gathering of persons for a specific purpose and includes demonstrations, protests, meetings, processions, rallies, sit-ins, candlelit vigils, and flash mobs. In my view, therefore, is that there's an important aspect here that we need to be able to educate our people on. For you to then have, if you are to base it on General Comment number 37, for you to have an assembly, it must be a gathering of persons for a specific purpose. And see, you on 25th of of June, the families of the victims of the last year killings gave a notification that they want to undertake a procession to go and deliver a petition. And so, to that extent, that was an assembly that is protected by Article 37 and that is protected by General Comment number Article 37, but also the General Comment. But then, when other people then infiltrated it, and some said that they want to go to Parliament and occupy Parliament, some want to go to State House, and they want to effect a regime change, then in my view, that assembly therefore lost that protection of Article 37. And these are some of the things that we may need to educate our people on. So I want to conclude by saying I've found this quite enriching, just like Honorable Kaluma had mentioned. I would want to encourage Wakili FE and the Nairobi branch to continue doing this and probably, nudge the other branches to do the same. And through such forums, we can actually undertake proper civic education to our people and ensure that the country can learn its laws and we are able to exercise our rights effectively but responsibly. I am hoping that what Honorable Kaluma has mentioned will come to fruition and that we will all be engaged in a rigorous thought process to make inputs into that legislation so that we have a legislation that will actually help secure the rights, but ensure that the rights are not misused to the detriment of other people and to the detriment of the country. Thank you very much.
Thank you very much, Wakili. Hesh, Honorable Kaluma, your closing remarks.
Yeah, I think we have spoken as learned friends. Let me start by thanking you, Sheila, and the Law Society of Kenya team for putting this platform. By this platform, we have engaged minds objectively, we have shared perspectives, and let me thank you more that in as much as, there have been differences of opinions and perspectives, it has been very cordial, very learned, very engaging, very courteous, and very respectful. The material, of course, we have put together material, I think, that we should, carry forth as we discharge our obligations under the Law Society of Act in public interest and for the benefit of the nation. We will be making contacts. I would be requesting Wakili Sheila that these matters be consolidated, and if you find the time and opportunity as the council, let us, put them together in terms of resolutions, and let us, not, just lose them here. But lastly, to say that Kenya really belongs to all of us, and Kenya is the only state we have. Sheila, in 2023, I was addressing the EU Parliament on the security situation in the Horn of Africa. And I remember when I mentioned what could be done to secure Sudan, the Republic of Sudan better, the delegation from Sudan shouted me down and said they can deal with their issues. When Hatum then, exploded, the leader of that delegation who was shutting me down called me from Sudan and said he regretted what he did. And it happened to be at the time we were having the 2024 June 25th Gen Z demonstrations. And he requested me, he told me just one thing which I needed to end with. That number one, the continent envies Kenya for our rich Bill of Rights. But he said that we envy you You have a rich Bill of Rights, but don't lose your country in the enjoyment of those rights. And he told me a very painful thing, that when Khartoum, found itself in the situation it is, his home was raided by over 11 soldiers who turned, his own, wife and 2 daughters into, sex slaves, cooking for them and just raping them as he watches there. And that is where I want to end it, that we may differ professionally, we may differ at personal level, we may differ in terms of our political perspectives, but really when it comes to the existence and stability of the state, let us always be alert as lawyers that we can only enjoy the human rights and fundamental freedoms of under Chapter 4 of the Constitution in a framework where, Kenya is stable. And we should, as brothers, not, encourage situations where we destabilize the state. Otherwise, I'm grateful for the engagement. I cannot thank you enough for this platform. And I would request that in future, we also pick other pertinent, topics, and so that we engage. Even for us who are, not just advocates, but also, serving elsewhere, we should have platforms, Wakili Sheila, where you can just call us to say, today we have a platform, we have our members in parliament, we want to know the position on this, we want to know what is on this, we want to know what you are doing for us in this. Because when we were elected, really, the Law Society of Kenya celebrated. There must be a platform at which we engage with our, mother society and report back also to our mother society on, what we see wherever we are. I'm grateful for this engagement, and I'm grateful to all participants for engaging. May God keep you as we go into the weekend. Thank you very much.
Thank you very much, Mahesh. I don't know whether my chair who opened this forum for us is logged in. I seem not to see him. He could have dropped off at some point. But on behalf of the LSK Nairobi branch, in which I represent in council, allow me to thank you, members of the public and members of LSK, for creating time. As ably stated by Honorable Peter Kaluma, we shall be putting this into a resolution, what was discussed, and sharing with our members. We shall also forward the same to you, sir, now that we have your goodwill. Perhaps when we call on the other leaders, we ask that you ask them to also extend the same goodwill to, because they are members of LSK, to at least come and engage with us so that the betterment of Kenya supersedes every other intention. So finally, God bless you all for creating time. God bless Kenya. May you all uphold the rule of law and respect the Constitution, rule of law, and advocate for the public and the Gen Zs. May you also advocate mostly and greatly for Kenya, because that is home. God bless you. God bless the Law Society of Kenya. God bless the country. Asanteni sana for creating time.
Asante sana.
Welcome. Have a good evening.